Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 118 of the NCDWI Guy podcast. On today's episode, we have Sarah Olson. Sarah Olson, who is the Forensic Resource Counsel. She works with the Office of Indigent Defense Services, and Sarah provides a great overview of how to interpret the results that are provided in an SBI lab report. What can a lab analyst testify to? What things to be looking for in the lab analyst's curriculum vitae. Just a really great overview of how to analyze and attack the SBI lab results. You are going to learn so much on today's episode. There's going to be some just incredible practical points that Sarah delivers in today's episode. But more importantly, throughout the episode, Sarah provides kind of places to go for further resources and information. Please go to the website that Sarah has really helped to put together. That is a resource, a great resource for North Carolina DWI defense attorneys, for criminal defense attorneys, forensicresources.org, forensicresources.org. Please go visit that website. If you have a court-appointed case that involves an SBI lab report, or you are in the public defender's office, Sarah is your new best friend. She will help you walk through your case. She will analyze the lab results for you. She can really provide a ton of great benefit. Even on a privately retained case, give Sarah a call. I've called her about a number of cases, and while she can't, fully examine the report since it's a private case, she's been able to point me in the right direction. She has given me some resources, has been a huge help point on several of my own cases. So please give Sarah a call. She is happy to respond. At the end of today's episode, Sarah leaves her contact information. If you have an SBI case, if you have a case that involves a lab report, whether it's alcohol or drugs that are in the system, you've got questions about that lab report, Sarah is the person to call. You are wasting a humongous opportunity to help your client if you don't reach out to Sarah and if you don't check out the resources that she's made available. So excited to have her on the podcast. Hope that you learn as much from Sarah as I did. So I guess in terms of kind of some of the most common attack points on a blood case. So, you get a client that calls in, officer indicates, hey, I got a person I think is impaired by drugs, or they've refused. And so this is we're gonna get a search warrant to draw blood. When you have a client that is got that lab result that is going to come back, what is kind of the first steps that you want to take, whether that's kind of prior to the lab report actually being received from the SBI, coming back, what steps do we take before that, or once the lab report comes back, what are kind of some of the initial best steps on that side of things?
Yeah. Well, in terms of once you have the lab report, there's a couple of things that I always look at right away and talk to attorneys about. One of those is that the state crime lab does not measure the amount of controlled substances that they find in blood. And we're going to talk, I think, a good bit about that today.
Yeah, that's a big deal.
Yeah. And then the other one is I see a lot of marijuana cases or suspected marijuana cases where the lab is reporting. In the case of marijuana, they do report the amounts. And so a lot of times I'm walking through with attorneys the different substances that they test for in a cannabinoid case and what those mean. And I have a slide that I wanted to share. I thought it was
Yeah, so share away on that front again. Like I said in the intro, this is going to be a episode that is worth watching as opposed to just listening in, because Sarah's got a ton of great information that she's going to share visually, and some of this you can kind of only, I think, get a good sense of in terms of seeing it the way that it would be in a lab report by looking visually at what Sarah's sharing. So yeah, feel free to share away.
All right. So what I've got here is a snippet from a marijuana case. And this is typically what you'll see, that the lab has tested for 3 different substances and they report all 3 of them. You may, in some cases, just see 2 of the 3 reported, but in a lot of cases, you'll see all 3. And so this is kind of where I start with a lot of attorneys, trying to help them understand what these substances are. So what the lab is doing is they are testing for the presence of THC, which is the psychoactive substance. And then they also test for 2 metabolites of THC. So when THC breaks down in your body, it breaks down into these 2 substances. We'll just call them 11-OH-THC and THCA. So 11-OH-THC, that's an active metabolite of marijuana or THC. And then the THCA is an inactive metabolite. These 2 metabolites, they really can't say anything about whether your client was impaired or not. So if these 2 are the only substances that you're seeing in a lab report, then the lab does not have, there's not enough there to say whether your client was impaired or not. If they also have THC present, then it's worth looking at the amount. And just as like a really broad strokes approach, I look to see whether the amount of THC is above or below 5 nanograms per milliliter. So in this case, it's 4 nanograms per milliliter. And the reason I look at 5 is that some states have a per se limit for impairment for marijuana, and they set it at 5 nanograms per milliliter, like we have a per se limit for alcohol. Oh,
that's interesting.
North Carolina doesn't have the per se limit, but several states do, and they set it at 5. So if you've got something, 5 or below, then I think you really have something to challenge about whether these lab results can say anything about whether your client was impaired or not.
Yeah, that's super helpful. I was not aware of that, in terms of those other states. So, I mean, that would be, something that at least you could offer and as persuasive authority, if this is what the limit is that we're looking at. That's really helpful. In terms of, I've had conversations. One of the things that I tend to do on most of these lab cases where the analyst is coming in to testify is I will ask, before testimony begins, I'll ask the lab analyst, can I step outside with you for a few minutes and, just go over this report with you? And most of the ones that I've ever talked with out of the Western lab primarily have been incredibly helpful, and a lot of times offer some, if you want to call it like damning kind of evidence, or, hey, this is what this means, and explain it really well. And, say maybe this isn't the greatest thing for the state's case, but, in a lot of the back and forth, they've been pretty helpful on that front. In terms of that, THC, THCA conversation, what in terms of the questions to ask the analyst, whether it's during direct examination or maybe outside, how would you maybe phrase that to the analyst in terms of, again, what they're allowed to say? Well, this appears to have caused a actual impairment with this, but by finding this particular substance, we would expect that person might be impaired, and what they're allowed to talk about on that front.
Yeah, well, I guess a couple things. So first of all, I would try to use the information to negotiate the case. If you have no THC present, I think that's something that you may be able to use to negotiate the case, depending on what the other evidence is.
This may sound kind of silly, or maybe we've got a pretty active prosecution here in Buncombe County, but in terms of that negotiation standpoint, Do you think it would be helpful to go talk to the analyst about that first and then almost present it to the DA through the analyst? I'm trying to, I guess, maybe figure out what the analyst would kind of tell the DA here, because a lot of times I don't think these type of questions are asked by the prosecution of the analyst prior to trial. It's just like, hey, we know that there's marijuana in the system based on what the lab says. So we're calling the analyst in, and really the first kind of true conversation is once the analyst gets on the stand. So any suggestions in terms of how they kind of use that as a, kind of plea negotiation tactic?
Yeah, I mean, I think you're definitely right. I think probably most DAs are seeing where it says THC here and THC here. Like if these are the only two things you have, they just see THC and they think that that's an impairing substance. So yeah, I think there's a lot of education that can be done, of prosecutors. And I think you're right that might be helpful if it were coming through the analyst. And I think it's great what you said about meeting with the analyst before they testify. I also, I definitely encourage attorneys to do that, and also wanted to just remind people that analysts are available to meet with you even before trial. It's their lab's policy that they have to meet with you. So once you get the lab report and you see who the analyst is, all you have to do is call up the lab. You can even email the analyst. Their email is usually their first initial last name at ncdoj.gov, and just tell them you want to, talk to them about the lab report.
Yeah, that's great
advice. Yeah, and like you said, a lot of times there is something helpful in there that you may not realize, that they can educate you about. And then maybe that's something that you might want to try to bring to the DA in negotiations as well. I also have some information that I put together about marijuana and impairment, and I put it in a...
Just before we move on to that, sir, and feel free to go ahead and pull that up. But yeah, in terms of that kind of, again, expected testimony of these three substances that you just went through, THC 11, OTH, THC, and THCA, in terms of the expected testimony that would come out if those substances, either, THC or the derivatives show up in the blood, like only the derivatives, how would you expect the analyst to kind of talk about those things, generally speaking? I mean, is that going to be something that you would expect if they see only the derivatives, that they're going to be able to kind of communicate that effectively if we can't really use this meaningfully? Or how would you kind of, obviously every analyst may testify slightly differently, but what would you kind of expect that kind of testimony to look like?
I don't think it's up for debate whether the metabolites indicate impairment or not.
Okay.
Without the presence of THC, I think anybody would be really stretching to say that they could form an opinion about impairment based on just the metabolites. And so what I did in this blog post, it's up on my website, forensicresources.org, is I pulled together the scientific literature about marijuana impairment and put links to all of the reports that I cited to. A lot of the reports are from NHTSA and other, sources that prosecutors would respect. And so these are places to go that all back up the fact that, the metabolites are not sufficient to form an opinion about impairment. Also, I wouldn't, we talked earlier about the 5 nanograms per milliliter. I wouldn't, if your client has 5 nanograms or more, I wouldn't say that that's per se impairment either, because there are publications that say, it's difficult to form an opinion about impairment based just on the THC. And I wanted to show you a couple of slides from NHTSA. They have...
I'll share that link with the podcast notes. So anybody that wants to go to that, I'll share the link.
Awesome. So I'm sure y'all are all familiar with with NHTSA and their reports, but they have a drug and human performance fact sheet for each drug, including marijuana. And in that fact sheet, it says it's difficult to establish a relationship between a person's THC blood or plasma concentration and performance impairing effects. It also says it's inadvisable to try and predict effects based on blood THC concentrations alone, and it's impossible to predict specific effects based on this metabolite. Here it's called THC-COOH, but our lab calls it THCA.
Okay, that's great.
Yeah, so I think you can find some really helpful information in like the state's own scientific research, and I've tried to highlight them, and I'm happy to share these, with your listeners so that they know exactly where to find it. And I've put sites to it in that blog post that I shared.
Yeah, I think this is really helpful in terms of just decoding, especially marijuana, which is obviously one of the more common impairing substances that is found in somebody's blood. Just having a basic understanding of that, because again, education is the way to attacking on these type of things. I mean, once you get that lab report in, if it's the mindset of, well, again, I'm talking to my client, looks like there's, marijuana showing up in your blood. You told me you smoked earlier, or, within the last 24 hours or whatever it might be, that conversation was, to kind of immediately move into a plea conversation is not, by far not necessarily the right move, just depending on what, other indicators of impairment there are, and what the lab report actually says. So just getting a better understanding of what that lab report means is so helpful. So I'll definitely share those resources. I think that there is such ground. I mean, that, the research that continues to kind of come out on the impairing effects of marijuana is pretty defense favorable. So hopefully, again, if you've got somebody that is moving around, normally and doing well on the field sobriety test, the fact that, even if there is THC showing up in the blood, there's just a lot of good literature that just says, THC concentration doesn't correlate well with somebody that's appreciably impaired, and obviously that those links that you've talked about are a great resource on that front. So yeah, definitely check those out. If you've got a marijuana case, this would be the links that the blog that Sarah's written, as this is a great place to start. So sorry to derail you on that front.
No, always happy to talk about marijuana and impairment. And like we were talking about earlier, the three things that they test for, those last two, the metabolites, like they can stay in a person's blood for hours, for days, sometimes weeks, depending on how regular of a user the individual is. So definitely, just because you see THC in a lab report, don't think that means that the client was impaired. Definitely do some more research.
Yeah. And again, once you've done some of that research and then you call the lab analyst, I think, again, those are the kind of questions to ask the lab analyst. So you know what the answers are going to be when you're in trial. But again, how long does THCA stay in somebody's system? What can you tell about, a person's use of marijuana based on, this THCA finding that you have in the report. So again, getting I feel like because it's sent to the state crime lab and you've got a state analyst who is subpoenaed by the state and required to be there by the state. We always see these people, I think, or early on, I saw this as a, adversary, right? Like somebody that's there to attack only. And again, every lab analyst is different, but I found the lab analyst to be relatively helpful when it comes to, we're just here to, we were called in as a witness by the prosecution. We're here to tell what our lab report means. And, generally speaking, I've not stretched the truth or gone outside of the bounds of what they're allowed to, talk about. So I think you can kind of turn the lab analyst into one of your best resources. I had a case not too long back where the lab analyst was basically kind of like, there was nothing found in the system, nothing, no impairing substances were identified. And, they still called the analyst because I think they were trying to say, well, you can't test for everything, or I don't even remember what the line of questioning was, but the lab analyst was super helpful. And basically, kind of just said at one point, I think part of the state's problem was that there was a screening a screening test that showed a positive indicator, but then no confirmatory result. And so that's what the prosecution was attaching to. And I think the lab analyst at one point said, we've actually now taken out the, screening results because it's been causing confusion among the DA's offices, basically. So it's like a real, kind of helpful conversation on that front. So again, I think it's just helpful to have that background and then talk to the analyst about your particular case. So in terms of once you get that lab report back, you look at what substances are identified, what's kind of the, low hanging fruit or some of the major challenges that can be brought, whether it's to, specific impairing substances or to, whether or not the state can show, obviously any quantitative result that comes back. What are some of the kind of common attack points that you see as you're getting, kind of these cases bounced off of you?
I think probably one of the most common attack points is that the lab has not quantitated the amount of the substance that's found in the blood. Except in the cases involving marijuana, the tests that they do, they just test for the presence of a substance, whether it's there or not. They don't measure how much is in the blood, and so without knowing how much is in the blood, it's very difficult to reach an opinion about whether that says anything about impairment or not.
And so in terms of just kind of fleshing that out and how you walk through that with the analyst or what that, what to look for in the report, just kind of go a little bit further into kind of explaining why that's an important aspect.
Yeah. So there's so many factors that determine how a substance is going to affect an individual. The controlled substance or any type of medicine that you might take affects each individual differently. And one of the big factors to consider is what type of tolerance a person has to a substance. So if somebody has experience taking a drug, like let's say they take they have a fentanyl patch that they use regularly to medicate for pain. They're going to, develop some tolerance to that. They might have to increase their dosage from time to time to keep, their pain being correctly managed. And they might get to a level that they're taking that, like if a novice user took it, like they might take that level every day. But if a novice user took it, they might die from taking that same amount of the substance. So it's really important in order to understand how a drug is going to affect an individual, you really need to know what their history is with the drug. So even if you did know the amount of a drug that was in somebody's blood, you still don't know what their history is and how they as an individual would react to that amount. Other factors that also affect how an individual, reacts to a drug are things like weight, age, sex, and like I said before, whether they're taking the drug like recreationally or they're a novice user or whether they're habituated to it.
And so in terms of, I guess, bringing that out, and the reason that's important is, again, I think one of the kind of immediate conclusions, I think what we can draw as attorneys when we get that lab report back is, almost like, oh, shoot, it looks like there is something that showed up in my client's system. And so, again, in terms of like communicating that in front of the judge, really, would it be, is this kind of like a fair characterization, like the result of there being a substance found in the system outside of Schedule I and alcohol with a specific concentration, the result of there being a specific substance in a person's system would really be like the same as like a positive indicator of alcohol on a PBT. Is that kind of like a good comparison?
I think so, or maybe even less. Like I would imagine that the PBT level has like something to do with the amount of, alcohol that they have on board, even though it's not completely accurate. But the lab isn't even, getting like a sketch of how much might be in the system. They're just saying, is it there or is it not?
Okay. That's good to know. So again, I think in those situations, then really, the way to explain that then to the court, if there is this, confirmation of an impairing substance being in your client system, is we still have to look to see whether or not the state has proved appreciable impairment in this case. The fact that that kind of impairment, what the signs and indicators are, seem to match up with this particular substance's expected effects. That these things kind of at least correlate to one another, and this would be something that you would expect to see from a person that's impaired on this particular drug category. So in terms of that communication to the court, I think, again, this is all about, to me, all about education. First of all, kind of educating ourselves primarily. I think that's where we really can take a major step forward as a defense bar. But then, our job is really to educate the judges. And I think for many judges, they kind of have the same attitude, and I would say maybe, reasonably so, that a lot of defense attorneys have when they first start looking at these reports, is it's like, oh, there was an impairing substance in this person's system, therefore they're impaired by that impairing substance. And so explaining, again, this really doesn't mean anything. We still have to see what is the appreciable impairment in this case. And again, once again, using the lab analyst to kind of further that, right? Like, based on the fact that I found or confirmed that this impairing substance was present, I don't really have the ability to say whether or not this person was impaired. I can tell you maybe what the impairing effects of this particular substance might be, but in terms of whether it was causing impairment in this individual, again, without having any quantitative analysis to go off of, it's really difficult to kind of say whether or not there would be impairing effects. So, go ahead, Sarah.
Yeah, I think that raises some interesting points in how you might use the lab analyst. In a lot of cases, the lab analyst may be, like you said, able to testify about the potential impairing effects of a substance. And then in a lot of cases I've seen, those are different from what the officer observed. So it might be a substance that like depresses, the different, functions of the body, but the officer is seeing like, agitation and excitement or something. So, a lot of times those clues that the officer has identified are different from what the person would be, displaying if they were appreciably impaired by the substance that the lab found. So I think that's another way that you might use the analyst to educate the court. Also, you might use the analyst to talk about like how long the substance stays in the body. They'll know how long, they'll know like the half-life, how quickly it's eliminated from the body. They'll also know, how long the impairing effects of the substance may be. So, you may want to use them for that information as well.
Yeah. And I think just going back to, having that, as you suggested, in terms of, and I think this is just such a great practice point, reaching out to the lab analyst before the court date, that could really help you in determining whether or not you want to kind of require the analyst to be present, right? Because generally the DAs would prefer to proceed forward just with the result, if they can. And maybe, for a lot of us, we're thinking, oh my gosh, I don't want the lab analyst to come in here and, talk about this. But again, that may very well like contradict what the officer was seeing, or it might kind of minimize the value of what the report says. So having that conversation early on, I think, could really help you evaluate whether or not to even ask, or to file a notice of objection to have the analyst come in and testify, or to basically, be like, well, this isn't going to be a good case for the analyst to come in and talk about. So,
yeah, I wanted to share some information, this drug data sheet. I don't know if you've seen them coming into court recently or not, Jake, but I've seen these. In some cases, analysts will bring them into court, and they'll use them to testify. So for each drug, or each like general class of drugs that they're testing for, the lab will have this information sheet that has information about like the half-life of the drug, so they can kind of figure out how quickly the drug would exit the body, It has duration of effects, and then it has like the potential adverse effects that the person might either be displaying if they've taken the drug. It has a therapeutic range, the toxic range. And
This is great.
I have not seen these ever provided through discovery, but attorneys have sent me copies of these when the analyst comes to court and brings it and they get a copy, then they've sent them to me. So I think I have a few of these. I'm happy to share the ones that I have with attorneys. But this can kind of give you an idea of what sort of pharmacology testimony you might expect out of the analyst.
Yeah, and I think a good way to, again, just kind of at least maybe have an idea of what the analyst is going to say is if they are in the courtroom getting ready to testify and you ask to step out of the courtroom, you can, certainly ask, can you point me to anything that you've used in terms of just kind of getting up to speed on this case, or do you have a drug data sheet with you on this particular drug that I could look at? Because again, the whether it's helpful or hurtful to the case, better to know kind of going into it what the analyst is going to talk about.
Yeah, and at the bottom of the document, they have their references. So these are the sources that they're going to find this information. And it's let's see, like this basalt, disposition of toxic drugs and chemicals in man, and then also Winnick, and then the NHTSA drug and human performance fact sheets. So you can get these NHTSA fact sheets online. I'll show you in just a minute where we can get the Winnick information.
Oh, that's great, because that's such a great resource.
Basalt is a book. I'd recommend purchasing it. It's a great reference that I think all DWI attorneys should have their hands on. So let me just show you Winnick. So Winnick, what it does is it gives a therapeutic, a toxic, and a lethal level for different substances, and it's all in this chart that they've put together. And you can get to it if you just Google, let's see, Winnick drug chemical like blood level chart. You'll be able to find it online. I can also share these slides with you all. But I guess it's of limited utility because the lab doesn't report amounts, but it does at least give you some idea of what a therapeutic amount would be versus a lethal amount. And it's a source that the lab recognizes as a reliable source.
Yeah, that's great. So I guess in terms of just kind of talking with the lab analyst about that, I mean, in terms of it being within, therapeutic or normal range, or being at a toxic level, asking questions along those lines, would you expect they basically kind of just say we're not able to differentiate whether this is at a normal or therapeutic range versus a toxic range?
I would say probably. The lab does, they do have what's called a limit of detection. So below a certain
like
level,
the cutoff ranges.
Okay.
They're
not able to detect the substance. And so I wanted to just show you that document. Let me share again.
Yeah, because I've seen them kind of use that as like a back end way of trying to talk about like a quantitative result. So they'll say, we can't detect this particular substance at below this amount. So again, we don't know what amount was in the system, but we know it must have been at least X amount.
Right. So this is the State Crime Lab's Toxicology Reporting Index.
Okay.
I got it you can get it from their website. I also, on my website, forensicresources.org, I put the lab procedures up. Like I'll pull them off of their website and then put them on mine. So always best to go straight to the source and look at their website, because they'll have like the most up to date. But let me just back up. To get to theirs, you can go to ncdoj.gov, and then under How We Help is the State Crime Lab, and then you have to ask them for permission, like a login and password, to access their procedures. So I encourage everyone to do that like right now, when you don't urgently need it. It'll take them like a day or less usually to give you access. But go ahead and do that now. And then you'll have permanent access to their database of procedures, and you can see like the most up-to-date information. But if you haven't done that and gotten your login, you can always go to my website. You don't need a login or password for that. So you just go here where it says crime labs, go to state crime labs, and then I've got their procedures by discipline. So for toxicology, you go here. Most of them are in this technical section, and this explains like how the analyst works each instrument that they use, and that can be really helpful to understanding.
That's great.
Like,
Jeez, that's
the
wild.
actual testing. Yeah. But what I wanted to look at is under forms. It is called the Toxicology Reporting Index, and we'll look at the most recent one. So this is the document where they report like what their limits of detection are. So for their immunoassay, they'll put like the limit here, and then over here it has the therapeutic range. Let me see if I can make it a little bigger so y'all can see it. So for amphetamines, they can detect as low as 20 nanograms per milliliter, which is within the therapeutic range. For phenobarbital, they can detect down to 300 nanograms per milliliter, but the therapeutic range is 10,000. So they're like detecting something way below the therapeutic level. So for whatever substance is found, whatever's in your lab report, it's worth looking at this document to see, what the lab report says the therapeutic range, and then like what level they can detect at, and they might be able to detect like way below the therapeutic range even.
That's so helpful. This is the first time that I'm seeing this here, and it's sometimes you just don't know what you don't know, and appreciate so much you having all these resources available. I feel like anytime that you've got a lab and you can kind of immediately figure out where to find this information, that is such a huge advantage. So again, all of this will be shared link wise, but this would be the first place to go check out if you get a lab report back with a specific substance, because knowing what that specific substance can be identified at or confirmed at versus what the therapeutic range is. Again, these are questions that if you're not asking them, I pretty much guarantee you the state is not asking these questions. I mean, typically they really don't care, or they don't, really haven't taken the time. It's just really trying to get into evidence that there was, a impairing substance in the system. And that's really the kind of the whole, that's not true of every DA, but certainly, there's a lot of kind of a lack of questioning on the DA's end about what all of this stuff means. So if this isn't coming out through cross-examination, it's probably not coming out at all. And again, as Sarah mentioned earlier, if you've got this information at the ready and you've had a conversation with a lab analyst, this may be a great grounds to go to the DA and say, hey, look, this is where the level was, identified at. Here's what the therapeutic range is, or, whatever you might want to share about your specific client in terms of medical history, that type of thing to kind of further those negotiations. But this is definitely helpful because, again, I think educating the judge, educating the DA, that's going to be, critical in trying to get that best possible outcome for the client. So this is just such a powerful resource. I really, really am amazed by how accessible this is. So,
yeah. Well, I wanted to take a step back even further. A lot of times when I look at lab reports, like what I'll see is like a whole laundry list of substances that were identified in the client's blood, and it looks like they've taken like the whole medicine cabinet. And like honestly, where I start is online, like looking up what each of these substances is, so that I understand what it is. And a great place to look up a substance, I mean, you can Google it and look at like Wikipedia. A really reliable source you can go to is PubChem. It's from the National Institute of Health, and it goes through and it gives like all the chemical information about the substance. It also gives information about the pharmacology, how it affects the body, also how it's metabolized in the body. So lots of great information and reliable information in this PubChem website. And often what I find is like you'll see maybe there's like 5 substances that were found, because we know that the lab is testing, like these are all the substances that they can test for, and it's a lot. And if there's like 5 of them reported, maybe, 2 of them are substances and the other 3 are metabolites of those substances. And you're not going to know that just by like looking at the names. Look it up online and find out, really how many substances the person has on board. I've noticed a couple of things on here that aren't even impairing substances. I saw loratadine on here. Do you know what that is?
No.
Jake? You might have taken it this morning. It's Claritin.
Oh, is that?
So, there's lots of stuff. Like you might see that on a lab report and you think, oh, great, my client has loratadine in their system. So it pays to just Google it, look on PubChem, and figure out what these substances are and what exactly your client has on board.
Yeah, and I think, practically speaking, that is definitely, again, one of the main things that the state is arguing in a lot of these cases where there is 2 or multiple impairing substances found is, looks like your client was on this like cocktail of, impairing substances that, again, yeah, they're just, totally out of control when it comes to medications. And like you said, maybe there's really only like 1 or 2 substances actually in the system. And these are all just derivatives of that.
Mm-hmm. Yep.
In terms of the, conversation with an analyst. So one of the things that you had brought up kind of prior to the call was kind of keeping the analyst within their specific discipline. And, kind of what is the analyst allowed to talk about? What are they allowed to testify about? So just talk a little bit about maybe some of the strategies on that side of things.
Yeah. So most of the analysts at the state crime lab, they do receive some training in pharmacology, like how, substances affect the body, how they're metabolized in the body, but it's limited. Most of their training is about how to test for these substances. People working at the crime lab, they're not medical doctors, they're not pharmacologists, and I mean, everybody's different at the state crime lab, but many of the analysts just have, a pretty basic understanding of pharmacology. So if they're going to be offering testimony about the effects of drugs, you definitely should be, considering objecting to that or having a 702 hearing to challenge expert testimony on pharmacology if you don't think that the, particular expert who's going to be testifying in your case has the qualifications. I think it's, both a relevance issue and that they don't have enough information about your individual client to testify about how they would be affected by the substance. So all they can give is really general information about how like the average human being would be affected by, cocaine or whatever the substance is. So I think you have a relevance issue there. And then also an issue about, the qualifications of the analyst and how much training they actually have on that specific substance. I've seen in Superior Court in Durham, Paul Glover was being offered as an expert to testify about effects of fentanyl. And the court actually kept his testimony out. They walked through like all of his training and, he really only had like 1 course that would have addressed drugs and, fentanyl would have just been a small part of that course. And, the court found it persuasive that, he didn't have enough, he might be qualified to testify about other things, but the court found he wasn't an expert on, the effects of fentanyl. So I think that that's something that could be challenged in a lot of DWI cases, that the experts just don't have like the depth of training to offer expert testimony on it.
Yeah, that's huge. And I love that idea in terms of 702, really kind of talking about how they're applying that to the facts of this specific case, because again, every investigation is different, but where you have, an officer that is, doesn't have any NHTSA training or has had limited training on investigation of DWIs, has not been through ARIDE, has not been through, certified as a DRE. You have this officer that's using tests that are kind of designed for alcohol impairment, CNS depressant, type investigation. And it's just like, well, this person's acting weird. They don't seem to be doing well on the field sobriety test. They're acting weird. I think they're negative on the PBT, but something's got to be going on. So go get a search warrant to draw blood. And now, the state is bringing in the lab analyst to somewhat kind of act as that DRE to kind of explain, okay, well, here is what the impairing effects, would look like. And again, since we're not applying it to this case, we're just saying, hey, here's what the impairing effects of this would be. Well, that kind of matches up with what we're seeing, in terms of the roadside, that, those seem to be, similar in terms of what analysts has talked about. So I really do think it's important to, like you said, challenge that testimony, because that really may be the only connecting point between what's in the system and the fact that there's any impairing effects at all. And it's just based on this general, very, very kind of low level understanding of what the impairing effects of that particular substance are, maybe even just the fact sheet that they've got.
Yeah. And I think that, the Babbage case can be helpful
Yes.
in this argument. It's 252 NC App 165. It's a 2017 case, and it involved retrograde extrapolation. And in that case, the Court of Appeals said that the expert shouldn't have been allowed to testify because she had to make assumptions about the defendant in order to, to do her calculation. And I think the same, is going on in a lot of cases involving drug impairment, that the expert would have to make a lot of assumptions about your client in order to, offer any information about whether your client was impaired. So I think that Babbage might be one way to argue that sort of testimony shouldn't be allowed.
Yeah, I've never really thought about using that in any other context. Then retrograde has certainly been like a golden case on the retrograde side of things, but I've never kind of thought about extending that outward. So that's, go check out that case that Sarah just referenced, because that is a really helpful way to use that in the 702 analysis of a lab analyst. That's really helpful in terms of
I've got one other 702.
Oh yeah. Go for it.
Cool. So I think we talked a little bit, Jake, about analyst certification and whether analysts have to be certified in their discipline. So back in 2011, the North Carolina General Assembly passed the Forensic Sciences Act. That was like in the wake of the Greg Taylor case, and there was, a lot of investigation of the state crime lab, a lot of, issues came to surface. And so one of the responses from the legislature was to pass the Forensic Sciences Act and require that everyone who works every scientist at the crime lab become certified in their discipline. And most of the analysts who are eligible have taken the exam and become certified. But some of the analysts, I believe, don't yet have enough work experience, like some of the newer analysts. They may not have enough years of experience working in forensic toxicology to have taken the exam. So I always encourage attorneys to look at the analyst CV when you get it. And there's a section on the CV that where they have the analyst professional affiliations and certifications, and it will list if they are certified. So the certification that they are supposed to have, according to the statute, is from the American Board of Forensic Toxicology. This is the one that matters. If they may have other affiliations listed here, and that's great that they are affiliated with these other organizations, but this is not what's required by the statute. And if you're seeing that the analyst,
can I just interrupt you for 1 second here? So in terms of, I'm just trying to make sure that because I want to make sure that I understand how we can use this. So if you've got an analyst that isn't certified by the American Board of Forensic Toxicology, how would you practically kind of use that knowledge in terms of either attacking the result or testimony? What does that look like?
Yeah. Well, so first, hopefully you've gotten the CV. You may not have their CV until they're coming to court.
Okay.
But if you're having that conversation, before trial, you could ask them if they've been certified yet. You can also go on the website for the American Board of Forensic Toxicology, and they list who is certified or not. So
okay.
First, check and make sure whether they are certified or not. And then if you discover that they're not certified, either because they haven't been working long enough at the lab or because they've taken the exam and failed, then I think that you should be challenging their testimony through Rule 702.
Okay.
And saying that, arguing that they do not have sufficient qualifications in the field, and they haven't demonstrated that they have those qualifications, and so that their testimony should not be admissible. I don't know.
That's based. So you were referencing a statute that kind of would mandate that certification. Do you have that on hand in terms of what to reference on that front?
I do. It's let's see. I've got it up on my website. If you go to Crime Labs and general information, I've got some information about Analyst Certification, and it has a link to the Forensic Sciences Act. So, the Act says that they have to be certified, but it doesn't give any remedy if they're not certified. It doesn't say they can't testify if they're not certified. So, you're stuck just making an argument, and I think your best argument is that they can't satisfy Rule 702 and show that they have sufficient, training and education in order to be able to offer expert testimony. I think it's something that you could use, in support. Maybe if you have other 702 issues, bring this one out as well. I don't know of any cases where an expert's testimony has been excluded because they're not certified. But it's an additional avenue of challenge.
Do you think that there is still a legitimate challenge on that front if they weren't certified at the time of the analysis? So, obviously some of these labs take, 8, 12, 15 months to come back, maybe longer. And then, the case may not get tried for another 4 to 6 months after that. So a lot of these things can drag on for a while. So if they're certified within that time frame, do you still think there's a legitimate attack based on that?
I think it's worth making the challenge. And so that's why, I said, look on the website to see if they are certified. It might not be on the CV that was supplied in the discovery packet, but they might have become certified, in the interim before your case is tried. But if they weren't certified when they were performing the analysis, then they haven't, demonstrated that they, can accurately do this type of analysis. And I think it's worth raising in a 702 argument. Now, they do have to take, competency tests that are provided by the state crime lab before they start doing casework. So, they're going to have some responses about, how they know that they are qualified to do this work. But, statute requires that they become certified. And I think until they become certified, they are vulnerable to 702 challenge.
Yeah, that's really helpful. I think that the other thing that, and this isn't necessarily like a specific attack point here, but I think just one thing that I've kind of found through, practically taking these things to trial is, a fair amount of analysts have very little experience in terms of courtroom testimony. Whether that's because, just a lot of their cases don't end up going to trial, or they just take so long to actually get to a point of trial. And then there's a fair amount of turnover that goes on in a lot of the labs across the state. So, I think in my head, when I first started practicing, when I saw a lab analyst, I was expecting somebody that, was coming in with the white coat on and, 20 years of doing these things. And that again, that may be the case in your particular situation, but may not be. So I think, again, one of the advantage points of, again, from a practical standpoint, one of the advantage points of talking to the analyst is they are just as generally nervous about getting on the stand as you are nervous about asking them scientific questions. So if you start to have a conversation with them, I think they kind of want to know, what am I here about? What's going on? So the more you can have that conversation ahead of time, again, I think it just creates a little bit of a, more trusting relationship. They've been given, generally speaking, very little information by the DA about why they're in the courtroom. Again, the DA is thinking we've got the substance in the system, and then defense objects. And again, the DA may be like, well, the only thing that I need to get out is that this is in the system. And the analyst is kind of like, I don't really know what I'm here to talk about. Again, whether that's helpful or hurtful, I don't know where this is going. So, I think the human perspective of somebody not really having a comfort level being in the courtroom can work to the defense's advantage in terms of divulging information about the case.
Yeah, you're exactly right that a lot of the analysts don't have a lot of experience testifying. And unfortunately, there's a very high turnover rate at the crime lab, and there might be many reasons for that, including like lack of adequate funding for the lab. And in part because they're required to become certified, like these analysts become very marketable once they are
Yeah.
certified. It's, it's rare for somebody to have that certification. And so once they do, other labs snap them up. So yeah, you may be encountering analysts who have, less experience in court, far less experience in court than you do.
Yeah, in terms of any kind of other pointers with regard to a lab analyst testimony or other resources that we haven't touched on, again, I think there's kind of like an endless amount of information, but in terms of kind of, again, that like, here's the primer or starter. Again, I still feel I've had a number of lab cases, a number of times where I've cross-examined an analyst on the stand. And I feel like, again, just during our conversation, I've learned so much about things that are out there, ways that we could attack. So what is maybe some of the other for somebody that, is taking their first, lab case to trial? What are some of the other either resources that exist or kind of practical tips that you might offer on that front?
Yeah. Well, I wanted to talk a little bit about what type of lab report you're getting. In most district court cases, I think attorneys are getting like a 2-page lab report.
Yeah. Here's the results.
Yeah. And just wanted to, remind everyone that that's not the full lab report.
Yes.
Unfortunately, like there's 2 types of lab reports. The first one, like the 2-page one that goes into the district court file, like it's called a lab report. But really, it's just a summary of the findings. And then the full lab report, it's going to have like the analyst CV and all of the tests that were performed. And you might find some of those like cutoff levels and stuff that you were talking about if you get the full report. The lab, in every single case that they work, they produce a full lab report. It's, often like in toxicology, probably like maybe 30 pages long. It's provided to the DA's office in every single case that they work, district court cases and superior court cases. So the DA has access to it. They're just not giving it to you. And in some jurisdictions, I know the DA's office will provide the full lab report to defense counsel in district court, but other DA's offices don't have that practice. But I just wanted to make attorneys aware that there is more than that 2-page lab report. And if you're, calling up the analyst before trial, to have a conversation with them, you might be able to get, some of the information that would be in that lab report that you don't have access to in that little summary that you get in district court. And then also, I know that some counties are starting to use remote video testimony from analysts at the state crime lab in DWI cases. And if you're in that situation, the DA really should be providing you with a full laboratory report. If you don't get a chance to object to the video testimony, it comes in, if the state gives you notice that they're going to introduce it 15 days beforehand, then they're allowed to do it. But they do need to provide you with a full laboratory package. If that is happening in your cases, I hope that you will insist on getting that full laboratory package.
Yeah, that's a great point. Again, yeah, I think that most of the time when you get that notice of intent to use, a lot of times it's just that summary report that comes along with the notice of intent. And, but I don't know if you have kind of any specific, again, just low hanging fruit that you see a lot in the full lab report of like places to look. But again, this is something that I have not been, near good enough about on my personal practice, is just having somebody that kind of knows what they're looking for in the lab report review that. Because again, you've got somewhere between, 30 and sometimes up to 130 pages or, even more than that information about what impairing substances are found. And if you don't know what that means, it's helpful to get a set of eyes on there that does. So any specific, kind of places to look on the lab report or maybe identifiers of should I reach out about this? Any thoughts on that front, Sarah?
I guess a few places to look would be where they are reporting, sometimes when they're doing the screening test, they'll report an amount related to that.
Okay.
That might be a place to look. Let's see. I mean, if you are able to get the full lab report, you really should be working with an expert to go through it. It would be challenging for almost any attorney to go through it on their own. If attorneys are getting full lab reports, I'm happy. You can send them to me in your court-appointed cases or public defender cases. I'll go through it with you, and we can walk through all the parts of it. Even if you're retained, I'm happy to do a quick walkthrough with you.
You've done that several times. I have learned a bunch, so I would highly recommend taking Sarah up on that offer. And obviously, again, if you do have an indigent client or you're at the public defender's office, to take advantage. This is a resource that is so helpful. Again, I've been involved in a couple of your CLEs, Sarah, and then also had the opportunity to have you help me go through a couple of reports, and it's just been, again, just a tremendous learning opportunity. Not necessarily every report's going to have some smoking gun in it, but you're going to learn a lot by having that conversation.
Yeah. Well, I wanted to share my contact information with everyone. If they want to reach out, probably the easiest way to find me is by email. Here's my phone as well. But definitely reach out if I can help you, go through a lab report or think through the conversation that you want to have with the analyst. I'm more than happy to do that. And then also, I often help attorneys to find experts on my database. On my website, I have a database of experts, so you can get contact information for experts in the field. If you need someone in toxicology, you can go here and get contact information for the experts. If I have their CV, I'll put a link to that. You can pull that up as well.
Oh, that's so great.
Yeah, and then I'm also happy, as attorneys are looking through this list of people, I can tell you kind of what the specialty areas are for these different individuals, and who, is more active in the work, and who, is maybe not working in as many cases. So, feel free to pick up the phone as you're looking through this list, and I can talk you through who's there. And then also under forensic disciplines, I have a page on toxicology. And you can go here to find information about the tests that are used. We try to explain the different tests in plain language that all of us can understand. And then we also put on the website the relevant reports that you'll need to know about. And then also any blog posts that I write about related to toxicology or DWI would be listed here. So this is a good place to go for some of the latest information that I'm publishing about toxicology and DWI cases.
That is so amazing, Sarah. I can't thank you enough for all of the resources that you've put together, many of which I've just found out about myself. So I've used the IDS website a ton. I've gotten my fair share of great free information there, but it's just awesome how much beyond what I knew was there existed that I've kind of discovered here just in our short conversation. So I'm eager to get on there and start digging into some more of those resources. But I will just again say, so there's been an incredible resource for the defense bar, in terms of education globally through CLE, obviously through her blog and website, but also on the individual level is very, very responsive. I've had a couple of times that I've bounced some cases off of you, Sarah, and you've been always very gracious and very responsive on that front. So I really appreciate all the work that you're doing on this. And I thank you so much for coming on and sharing the information with the audience.
Yeah, well, I appreciate you having me on. I really appreciate what you're doing, Jake, getting that information to all the attorneys, all your listeners. So I really appreciate being on, and I hope everyone will reach out if I can help you with your cases.
If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.